All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save the United States, great state of Florida, and this honorable court. Ladies and gentlemen of the Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on the docket today is Pincus versus American Traffic Solutions, Inc. Counsel?
Good morning, and may it please the court. My name is Brett Luskin, and I represent the appellant, Mr. Stephen J. Pincus, in this matter of certified questions from the 11th Circuit Court of Appeals. Your Honors, in 2010, the legislature of Florida enacted the Mark Wandel Traffic Safety Act, which enabled local governments in Florida to employ photo-enforced red lights on their roadways and set forth the parameters to which such programs must adhere. Following that, the city of North Miami Beach decided to avail itself of such a program, along with many other local governments in Florida. To accomplish that, the city entered into a written contract with the appellee, American Traffic Solutions, or ATS. Under that contract, ATS was to provide and perform all aspects of the photo-enforced red light program, including operating and maintaining the cameras, reviewing the footage for violations, issuing traffic citations, and receiving civil penalty payments from accused drivers for the city. In exchange for performing those contractual duties, the contract called for the city to pay American Traffic Solutions compensation in the form of a monthly fee. That fee is not at issue in this case. It should be self-evident that the city and ATS can agree amongst themselves in their contract how much the city should compensate ATS for performance of its contractual duties. It's elementary that they can do that. What they cannot do is agree amongst themselves in their contract as parties to that contract that someone else, a non-party, has to pay compensation to American Traffic Solutions.
Let me ask you this. This kind of goes to the heart of the case. The formulation you just made is that someone has to pay, or right?
Well,
I think those are the words you used.
Yes, according to the contract, yes, the accused driver has to pay this when they make an electronic payment.
So when they make an electronic payment, but it seems to me that would be the critical factor here is that the choice to make an electronic payment is entirely voluntary. Now, at some points in your briefing, you seem to indicate that there's a duty to make available as a matter of right, the ability to pay electronically. I don't know where that's written. If you could expound on that, that would be helpful. But it seems to me that this idea that's at the core of your case, that people were forced, you say they were shaken down, they were robbed, although you also say that this was your case of unjust enrichment does not depend on wrongful conduct. Well, I have a little trouble understanding how, on the one hand, you say people are robbed and shaken down, but it's not wrongful conduct that you're depending on. But explain to me how you get around the voluntary nature of this transaction that people enter into.
Certainly, Mr. Chief Justice. I think you've hit on the core of the case. And implicitly, you must understand, and this can't be overstated, I know we beat this to death in our briefs, but the relationship between American Traffic Solutions and Mr. Pincus and accused drivers is not at all voluntary. It's anything but voluntary. The only voluntary relationship in this case, contractual relationship, is between the city and American Traffic Solutions. And this is an important point. The American Traffic Solutions works for the city. They work for the government. They work against the driver. And that is fundamentally because a traffic citation is not a contract, and it's not an invitation to contract. On the contrary,
I think the point is, you would agree that the $158 payment is involuntary.
Yes.
But what you're complaining about is a $7.90 payment, and that is completely voluntary because you could avoid it by paying a different way. I think that's the nature of the voluntary act that the chief was talking about.
Yes, Your Honor, and I think this is the point I'm trying to get at, that it's an illusion that this is voluntary. You have to realize that the accused driver, such as Mr.
How is paying the $7.90 fee not voluntary if you can avoid it by paying in a different manner?
Because
it is lawful.
Well, it's because American Traffic Solutions they are dictating the payment terms here. You have to understand that
They do not dictate that it has to be electronic. A person can send it in by mail. The traditional old-fashioned way, and a lot of transactions still happen that way.
I think that's a great point, Mr. Chief Justice. I'd like to touch on that specifically. You describe paying by mail, by check, as the old-fashioned way. And with respect, I dispute that. I think that is wrong. And the implication here is that there's some kind of minimum that American Traffic Solutions has to provide to accused drivers in order to satisfy its obligation to fulfill this government role. And the minimum, if there is a minimum, is not payment by mail. In fact, I would submit that it's cash.
Well, where's that written?
That was written in federal law, Your Honor. It's 31 U.S.C. 5103, I believe, which is legal tender, which says that U.S. currency is legal tender, good for all debts, public and private, taxes, and public charges and dues. Now, I recognize this isn't directly on point with the matter at issue today, but I do think that it's relevant and important.
But you haven't argued that point throughout these proceedings, have you? That's not the point. You're not arguing that somehow this is defective because they don't take cash.
No, I was trying to address the point that Justice Lawson made. But if I can come back to more fundamentally, the reason they can't do this, getting down to it, is that it's prohibited by state statute. State law says you cannot add any additional fees, fines, surcharges, or costs to civil traffic penalties assessed under Chapter 318, and is assessed under Chapter 318.
Well, why don't we go to that point then? If a penalty arises under a chapter of the statute, every place it is cross-referenced in the code, what does it mean for a penalty to arise under it?
That's an excellent question, Justice Coriel, and there isn't an easy answer for that because assessed under is not a legal term of art. So we have to determine what the legislature meant, what was the intent of the legislature in devising this particular statute. And the first issue is, was it assessed under Chapter 318? And we assert that it is by the very terms of 318.121, as well as Chapter 318 generally.
Help me out with that, because all I see in 318 is a reference to the fact that the fee arises, or the charge arises, under Section 316.
Okay, so there's several arguments here. First, 318.121 strictly prohibits additional fees, fines, surcharges, or costs, except for 5 exceptions that are enumerated in the statute. The last of those exceptions in 318.121 is specific to red light camera cases under 316.0083. So as a starting point, it's what I describe as the classic exception that proves the rule. There is an exception where the legislature permitted precisely one additional fee that can be added to red light camera violations.
Would you concede that if Section 316 didn't provide for this penalty, that the penalty wouldn't exist?
If Chapter 316 did not provide,
yeah,
are you referring to the penalty?
Imagine that 316 is amended, but 318 isn't. And in the amendment, the surcharge, the whole red light scheme is struck out of 316, but for whatever reason, the legislature doesn't make a correction to 318, or at least not yet.
Let me try to answer that So if all of 316.0083 was vacated, then there's no mechanism for local governments to have photo-enforced red lights to begin with.
So
But
doesn't that mean that this really arises under 316 and not 318?
no, Your Honor, and here's why. Because the provisions that the penalty provisions that we're talking about in 316.0083 that specify that that there's a $158 civil penalty, those very same provisions appear virtually identically in 318.18. So it appears in both statutes. Only the wording is very slightly different, but all of the provisions are identical.
I'm sorry to interrupt you. Does it matter, though, that 318 by its terms only deals with citations, and this was a notice of violation, which is a precursor and a way to avoid a citation? So it seems like, to me, the whole notice of violation construct is completely a creature of 316. And 318, just on the face of the text, it's talking about people who are cited, and then in 318.18 it talks about penalties when there's a citation. So it seems like, at least in this case, and I don't know if it gets to the citation stage, I don't know how the payments work on that, but you brought this at the notice of violation stage, which seems to me is completely outside of 318.
And to answer that, the answer is no, Your Honor. The notice of violation, the amount of the civil penalty for a notice of violation is $158. And that sum, the $158 that's applicable to a notice of violation, that appears in both 316.0083 and 318.18 sub 15, I think 2 and 3.
But in that context, though, in 318, it's clearly referring to penalties where there's been a citation.
Well, actually, I disagree with that.
Well, I mean, you can disagree with it, but and this is super in the weeds, but when you look at it, you'll see that it's specifically talking about for citations.
If Your Honor will give me a moment, I will pull the statute and I can walk through this.
Okay.
I recognize that this is a little bit tedious, but in 318.18, which is entitled Amounts of Penalties, we have to skip.
Right. It says for a non-criminal disposition pursuant to section 318.14. But then when you go to 318.418, it says any person cited for a violation of chapter 316, blah, 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 is charged with a non-criminal infraction and must be cited for such infraction. So this is all at the citation and beyond stage. And the notice of violation is pre-citation.
That is true. The notice of violation stage is pre-citation, but I understand the reference, Your Honor. But in 318.18 sub 15,
right? But you don't get to 15. You got to start at the beginning. The penalties required for a non-criminal disposition pursuant to section 318.14, and then it has colon, and then it does 1, 2, 3, 4, 5. So.
Your Honor, I'm not trying to mince words with you. I recognize that this is a little bit tedious, but if I walk through the legislation in 15A sub 2 and 3, you will see that that's not what they're referring to here. These statutes that I'm pointing to refer directly to 316.0083 by their terms. It's just that it's a little bit circuitous to get there. So just if you bear with me, sub 15A3 says 100, this is the amount, $158 for a violation of section 316.74 sub 1 or section 316.0751C1, which are the red light statutes that are applicable. When a driver has failed to stop at a traffic signal and when enforced by a county's or municipality's traffic infraction enforcement officer. So this is the important language, traffic infraction enforcement officer. So to understand what that means, you then have to go to the definition section in 318, if you excuse me for a moment, which is 318.13, sub 5. Here we go. And what that says, in sub 5, it describes an officer and says that an officer is a traffic infraction enforcement officer. It includes a traffic infraction officer that is defined in the definition section in chapter 316. If you give me a moment, this will just take me a moment here, Your Honors. 318. Okay, 318.13 sub 5. The second sentence in here. Officer includes any individual employed by a sheriff's department or police department of a chartered municipality who is acting as a traffic infraction enforcement officer as provided in 316.640. So now again, we have to reference 316.640. And 316.640 in the relevant portion, defines, just a moment. Okay, and this is in sub B3. Okay, for the purpose of enforcing 316.0083, so now we're back to the red light camera law under 316, the department may designate employees as traffic infraction enforcement officers. And then there's a description of what these are, which essentially describes them as being responsible for issuing notices of violation for violations of red light cameras. So I recognize that this is a little bit difficult to parse, but I will represent to the court that when a uniform traffic citation gets issued after the notice of violation stage, the amount due is not $158. It follows the standard protocol under 316.075, and the total sum goes up to, I believe, $277. So it's a bit tedious to work through these statutes. But the point I'm making is that under 318.121, both by its terms, its own terms, and 318 generally, and the relationship between these statutes was clearly intended by the legislature to apply to photo-enforced red lights. And that makes sense considering that the entire Florida Motor Vehicle Code is designed to be a uniform set of laws applicable throughout the state, with each chapter dealing with a different aspect of the traffic law.
Counsel, you are now consuming rebuttal time. You may keep going, but you need to be aware you're in your rebuttal time.
Thank you, Your Honor. I will conclude here and resume my rebuttal at the end. Thank you.
May it please the court, Joseph Lang from Carlton Fields for American Traffic Solutions, Inc. With me at counsel table from the State Solicitor General's office is David Costello. I'm ceding 5 minutes of my time for Mr. Costello to address the money transmitter statute. If the court wants to talk about it, we didn't get that far at the beginning. I'm happy to answer any questions on any parts of this, but I'll try to focus on what we just talked about. But at the outset, I want to emphasize, especially given the ideas of extortion and embezzlement that were in the reply brief, I want to make clear so everybody understands, this notice of violation was for $158. $158 was collected, $158 was received by the city, and it was apportioned exactly as it was supposed to by the statute. Nothing was siphoned off. That's not even what this case is about. This case is about what happens after that notice of violation arrives at the violator's house, and the violator has to choose how to pay it. And the violator has many options that don't have any fees. Money order, check, no fee involved. You just pay the violation. But what you don't get when you send a money order or send a check is any sort of immediate verification that the fee is paid. You can't know for sure that the postmark made it. And that's important when you wait until the last day, as Mr. Pincus did in this case. The record reflects that this was paid on the last day. So an additional option that ATS offers with the authorization of the city through their contract is that you can pay online with a credit card or over the phone with a credit card. And when you do that, as is very common in the world today, there's a convenience fee associated with that.
Does the convenience fee also apply to debit card transactions, out of curiosity?
As far as I know, if you're allowed to use the debit card at all, it would apply, but I think maybe this is a credit card only situation, but I think any electronic payment would have the convenience fee.
So what you're buying, the convenience that the fee includes is the convenience essentially to wait until the last minute. You're buying time. Is that a fair statement?
I think there's more than that. Time, but in different ways. First, you don't have to have out-of-pocket money when you pay. If you can pay on a credit card, you can pay that over time.
That was why I was asking the question about the debit card.
Right.
Yeah.
you also get the immediate notification that it's been paid, a verification that it's been paid, which gives you peace of mind, especially if you're on the last day, but peace of mind whenever, that it's off my plate, I don't have to put it in the mail, I don't need to get my stamp, I don't need to get my money order if that's what's going to take, it's done. And so there is real benefit here, and if we get to it, I'd like to talk about why that benefit by itself is a benefit of the bargain that precludes the unjust enrichment cause of action that is going on here. Unjust enrichment is about mistaken transfers. There's nothing mistaken about the payment of this convenience fee. This was a knowing choice by Mr. Pincus. Nobody says that he paid more than he was told he was going to pay. He chose to make the convenience fee payment when he used his credit card. So this doesn't really fit unjust enrichment at all, but because what we talked about in the initial part of this argument is 318, I'll jump to that. Happy to answer any other questions, and I would like to touch just a bit on unjust enrichment at the end.
Counsel, before you do that, let me ask you, what do you think, if the court decided to rule in the city's favor, or ATS's favor, what would be the narrowest way for the case to be decided?
The narrowest way would be where I was going to start had we gotten there, and that is the benefit of the bargain doctrine. That would resolve this entire case because all three causes of action are based on unjust enrichment. And the restatement, to start with, black letter law, Florida courts, I don't think this court has ever adopted the restatement of restitution and unjust enrichment, but we have Florida courts that have cited it, and it's very well respected. Black letter law says that if in an unjust enrichment situation, if there's been counter performance, then meaning benefit of the bargain has been given, there is no unjust enrichment. We cited a long line of cases from the 11th Circuit and the federal district courts, including one state court case, a 5th District Court of Appeal case that I believe, Justice Lawson, you were on the panel for. And this doctrine has been uniformly adopted. Mr. Pincus did not grapple with those cases. He tried to make one distinction of the Batista case in his initial brief, and we showed why that distinction didn't work. And in the reply brief, Mr. Pincus just ignores the entire line of cases and tries to set this case apart as being different because he was compelled to deal with ATS. And while he was compelled to pay the violation, he was certainly not compelled in any way to choose to pay with a credit card. He could have paid with a money order or a check and not incurred the fee.
I'm sorry to interrupt you though, and I know we're not bound by it, but isn't there some tension between the benefit of the bargain argument and the Silver Star 11th Circuit case? I mean, in that case, it didn't say, at least in the face of the opinion, there wasn't any issue about whether the services had been rendered that the insurance company was being charged for, but essentially the court said that you could have unjust enrichment based on the fact that that the statute made the fees not chargeable given the ownership structure of the company. So, I mean, the benefit of the bargain thing, that seems like an attractive avenue, but am I missing something about how that relates to the case, to that 11th Circuit case?
As far as no, Your Honor, it's a great question because I've questioned how Silver Star came out the way it did, because it would seem the benefit of the bargain doctrine should have barred in that case too, but the 11th Circuit did not grapple with that. It didn't mention Baptista, its own Baptista case, didn't mention Pereira. It just didn't deal with that line of cases. And so while there may be some tension, it's largely because they didn't address it. They have these other cases on benefit of the bargain, and it either wasn't raised or they overlooked it, but it just did not come up in Silver Star. But Baptista, Pereira, and then the federal district court cases, you have a settled line. We, of course, think that Silver Star was decided wrongly under a different argument of unjust enrichment, the more general argument whether unjust enrichment can exist at all. We would say that it's just the wrong vehicle, the wrong cause of action to address a case such as
Well,
this.
let me ask you this. What if it was not voluntary, like in this situation, that the ability to send checks or a money order without paying this additional convenience fee was not there, or they charged the same thing for whatever method of payment? Is that a violation of the statute?
A mandatory
Yeah.
fee? Yes, I think a mandatory add-on would be a violation of, depending on what it looked like, I would say that it would either violate the commission, or if it's the vendor that's getting the mandatory add-on, I think.
So if that's a violation of the statute, and that seems right to me, it seems to be a good argument for unjust enrichment in that case, because it would be in violation of the statute collecting a fee not authorized.
I think the way the court ought to look is whether that statute creates a private right of action.
Well, we have common law causes of action for unjust enrichment, don't we?
There certainly is a common law unjust enrichment, but the problem here is the third prong. The first prong is that the plaintiff gives a benefit. The second prong is the defendant has accepted that benefit. The third prong is that it's inequitable for the defendant to keep that. The whole argument for inequity here is that a statute was violated, that the wrong...
Exactly. So in answer to Chief Justice Kennedy's question about the most narrow grounds, it seems to me the proper way to look at this to see, first of all, whether there was a violation of the statute. No, because it's voluntary, and then you never get to the unjust enrichment claim. Wouldn't that be the proper way to analyze this?
The court certainly can get there that way, answer it in the order that the 11th Circuit certified the questions. To do that, you have to rule on three different statutes. I guess that's the reason I would argue that the benefit of the bargain doctrine, because it covers the entire case, to get there on the statutory ground, because he has three different counts. He has a Chapter 316 count, a Chapter 318 count, and a Chapter 560 count. Now, I, of course, believe that the fact that this is a voluntary optional payment settles all three of those statutory arguments, but the court would have to address all three statutes to get there from the top down.
Did the city need to have an affirmative grant of authority to set up this mechanism in the first place? And if so, is it 215, 322, and does this comply with that?
No, we're aware of 215, and local governments can utilize Section 215. This fee is not limited like the convenience fee in 215. It does have a profit element to it. And out of candor to the court, you need to understand that it would not satisfy the Section 215. I think Section 215 is interesting because it indicates that convenience fees are understood by the legislature, and they're all over the place out there. As far as where is the authority to do this, obviously the legislature has authorized these type of programs. I mean, that is Chapter 316, 0083, and understands that vendors are going to be operating these programs. You can see that in the specific prohibition against vendors getting a per violation payment. They don't want to incent vendors to get a payment that's based on a per violation.
How can I understand, I'm very sympathetic to what you're saying about the private right of action, but how would, if it were an illegal charge, but something voluntary, like let's say that the 318, 121 argument were meritorious, what would be the proper way to have cities stop charging that fee?
Right. If there is no private right of action, which is assumed, I need to make that clear. It's assumed in this case that none of these three statutes has a private right of action.
And I don't think the other side
and I don't think they've
disputes
even
that.
argued otherwise. Then it becomes agency enforcement.
Right. What agency, though?
Department of Highway Safety and Motor Vehicles has the responsibility to enforce Chapters 316 and 318. And under 316, they have a more specific responsibility to monitor these programs, to issue an annual report, and to make recommendations for legislation that may be needed if they see problems with the way this program is running. So Department of Highway Safety and Motor Vehicles for Chapter 316 and 318. And as my colleague will explain, it's the Office of Financial Regulation for Chapter 560.
Okay.
Counsel, let me go back to the unjust enrichment. Has any Florida state court ever recognized an unjust enrichment claim based on a wrong arising from a statutory violation?
No.
Why would someone be wrong in thinking about claims associated with statutory violations in light of whether there is an express cause of action, and frequently there are express causes of action, or an implied right of action, and not try to shove this into such matters into the framework, which does not seem to be a comfortable fit with unjust enrichment. The history of that, all the circumstances related to that, the way that is set up, what would be wrong with looking at it that way?
We agree that unjust enrichment is a very ill-fitting cause of action for this. We think that the court's jurisprudence about private rights of action would capture these types of situations, and if the legislature either expressly or impliedly wanted there to be a private right of action, there are ways to deal with that under the law. What this is going to do, if you recognize unjust enrichment as being a vehicle for these kinds of claims, you're going to see claims like you rejected in QBE brought under unjust enrichment. That was a case where they tried to bring a violation of a font in the insurance code as a private right of action, and this court said there's no private right of action there. What you're going to see is attempts to bring that font violation as an unjust enrichment claim if these are allowed to go forward. We believe that the test ought to be, is there a private right of action? And if there is, then you go forward that way. You don't even need unjust enrichment at that point. But certainly in cases where there's no private right of action, we don't think there's a fit here. And I can answer any other questions. I see I'm out of time. Okay, I would like to cede some time to the state. Thank you.
Mr. Chief Justice, and may it please the court, David Costello for the Office of Financial Regulation. First, I'd like to make clear the office agrees with ATS. Mr. Pincus cannot state an unjust enrichment claim based on the money transmitter code. But I'd like to touch on a point that you raised, Justice Polson, and that's whether a statute can ever support an unjust enrichment claim. And we think that it can. The first step is to ask,
what basis in the jurisprudence of the Florida courts do you have for that position?
Well, I think Murphy recognizes that position, Your Honor. There, the court recognized there was no statutory cause of action, but there was a statutory obligation. There, it was a statutory duty. And the court recognized that that statutory duty could support a common law negligence claim. And so it just recognizes that statutes can support...
We're talking about unjust enrichment here.
Of course. And
no one's contending that there can never be an implied right of action arising from a statutory violation, right?
I agree with that, Your Honor. I don't think that that's what Murphy stood for, though. I think it was simply recognizing that the common law, it's constantly evolving, and it can adopt and adapt to modern standards, and sometimes the best standards are the ones that have been recognized by the legislature. And so if you take that premise and also note that this is recognized in the restatement in section 44 at illustration 12, it recognizes that there can be unjust enrichment claims based on statutory violations, even when there's no statutory cause of action. And so the question then becomes, when does that happen in the context of unjust enrichment? And you don't need to look further than the elements. A statutory violation results in unjust enrichment when the defendant will have inequitably received a benefit from the plaintiff as a result of the violation. And I think you were touching on this point exactly right, Justice Polson. If a violation of a statute renders a certain charge unlawful or unenforceable or void, that is the quintessential scenario when someone is holding on to a benefit to which they have no legal entitlement.
But how does that square with the whole concept that unjust enrichment isn't supposed to be fault-based in the first place? I think what the Chief's questions are kind of getting at is that whether there's a remedy that you might be able to find, this particular remedy just doesn't, it seems just kind of categorically designed to deal with other situations.
Well, I do want to be clear, Justice Muniz, that that does not turn on fault. In that scenario, if a defendant is holding on to something that it's not lawfully entitled to have, we don't care so much about whether the defendant is at fault.
But I mean, they violated so in this case, no one's arguing that, they didn't get, there wasn't some benefit conferred by, the fee and all that, and getting into the weeds of how much did that cost and all that. I mean, the only reason why we're even having this conversation is because it's the illegality, arguably, of charging the fee that makes it unfair to keep it, right? I mean, isn't that basically what you're talking about with statutory violations? I mean, that's the problem. I mean, that's what makes it a problem in terms of the injustice of keeping the money.
I understand your question, Justice Muniz. I think what's key here is that we are not living or dying, so to speak, on the statutory violation. It is the result of the statutory violation that results in unjust enrichment. So if you take Silver Star, for example, there you had a licensure scheme, the violation of which led to an underlying transaction being void or unenforceable. We don't care so much that the defendant violated the statute. What we care about is that now there is no basis for the transaction in the first place. There's no legal basis for the defendant to be holding on to a particular benefit. And so
only because the statute was violated. The arguments that try to separate the violation from then what happens afterward, I just don't. I mean, it doesn't matter, but I just don't understand that.
Right, and of course, Justice Muniz, if that were a holdup, we think that the cases that are standing for that proposition are federal district court cases, and we don't think they should hold this court back here. I do want to note, though, that even if a statute creates a legally protected interest, as we've used it in the briefs, I think another way is just to say that it's setting up an unlawfulness scheme, a situation where a benefit would be held unlawfully as a result of the violation. Even if the statute protects individual interests, nevertheless, the legislature can preempt common law. It can take that violation off the table. And we think that's entirely consistent with the restatement's position, and this is in Section 44, that if the legislature intended for something to not be actionable privately, then it cannot be actionable privately. And so if you just look at the statute here, the one we're in the case on, the money.
Well, see, what I'm struggling with is the gap between saying there is an implied right of action and somehow that the legislature did not create an implied right of action, but they didn't preclude claims arising from the violation through some other mechanism.
I see I'm out of time. Can I respond?
Yeah, please.
I think that the key here is that the legislature, we're not looking to whether the legislature has created anything new. That's what we look to when we look to legislative intent. Did the legislature intend to create a cause of action? But here, we already have the cause of action. It's a common law cause of action for unjust enrichment. And so if, as a result of a particular violation for which there's no statutory cause of action, someone is just holding on to a benefit that, as a result of the violation, there is no justification to hold on to, then the common law elements of unjust enrichment are just naturally met in the first place. And just to close, I will say that I think there are reasons why the legislature would choose to take a common law cause of action. For one thing, common law causes of action are time-tested. There is plenty of case law to rest on. Statutory cause of action, they need interpretation. And second, common law causes of action have inherent limitations that statutory causes of action might not have. So, for example, in Murphy, there was no statutory cause of action for negligence, but there was a common law cause of action, and the court found that important because that bound that claim in the economic loss rule, but that might not be present in a statutory cause of action. So for those reasons and the reasons in our brief, we ask that you find for ATS on the money transmitter issues.
Thank you. Rebuttal.
May it please the court, just a few brief rebuttal points, Your Honors. Mr. Chief Justice, you asked a direct question to counsel for ATS. Has there ever been a decision in Florida state courts where unjust enrichment was used to recover, I think I'm stating this right, was used to recover an illegal fee or tax imposed under color of law? The answer was no, and that's not correct.
But actually, I asked about a statutory violation. That's the way I framed the question.
Okay, well, the response from counsel for ATS was no, and that is not correct. There have been a number of cases out of Florida state courts where unjust enrichment was used in this way. Now, I don't believe there has been any precedent out of this court, but there are numerous decisions from DCAs throughout the state that support our position on this. And that falls into the doctrine
Give
of...
me your leading case.
Okay, the leading case I would say is Bill Stroop Roofing, which is, I can give you the citation.
That's the whole illegal exaction line of
Yes,
stuff.
illegal exaction.
But those aren't unjust enrichment cases. I mean, at least they aren't, the courts don't talk about them that way.
Well, I would say Parker versus American Traffic Solutions, which admittedly is a district court case, has a pretty good summary of this. And so just reading this here, he described, Judge Moreno starts, unjust enrichment is
I
not...
asked about Florida state courts. I love Judge Moreno, but he's not a Florida state court judge. He's a federal district court judge. The whole question was focused on whether the state courts of Florida have recognized such a cause of action.
Yes, Your Honor, he's citing to Bill Stroop Roofing. I just thought this was a better summary of the holding of that case.
Well, but you can't bootstrap it that way. If the underlying case is not talking about unjust enrichment, it doesn't fit the bill, does it?
Well, no, Your Honor, but Bill Stroop Roofing was an unjust enrichment case, was it not? I believe that it is, and I think that's why Judge Moreno was discussing it that way. And in fact, reading from Bill Stroop Roofing, the court says, in addition to this prospective relief, however, Stroop is also seeking a refund on behalf of itself and others for previously paid illegal fees, to which claim Miami-Dade County responds that it is protected by its sovereign immunity. That is, the county claims that it's a sovereign, and it can properly demand and extract monies from its citizens. Then,
I think that is an illegal exaction case, right?
Yes, Your Honor, but I believe that illegal exaction is a doctrine that falls under the heading of unjust enrichment. I mean, if the problem is just that we've titled the cause of action incorrectly, I mean, that's just an amendment problem. But I do believe it falls under the same heading of the court-fashioned equitable cause of action of unjust enrichment.
Are the elements the same?
I'm sorry, say
Are the elements the same?
The elements are not, there are no discrete elements that are discussed in the case law pertaining to illegal exaction, to my knowledge. But what I will say is that counsel said that it's the wrong vehicle to obtain redress in a scenario like this, and I think that's incorrect. And I think this case gives the court an opportunity to codify this.
Well, the unjust enrichment thing is the only, I mean, that's the hook that would, I think, probably unsuccessfully, but at least it gives you an argument about the voluntariness not being an issue. I mean, the illegal exaction line puts this in a situation where, since this obviously was not something that you were forced to pay, you chose to pay, you could have avoided paying it, the illegal exaction stuff is just completely unhelpful to you in that way. So I don't think that it's just a semantic thing.
Well, if I'm understanding, you're saying that in the typical unjust enrichment case, it's unhelpful to us because it's voluntary.
No, what I'm saying is in any illegal, you're saying in an illegal exaction case, all of those cases are things where the government said, if you want a license, if you want to do this or that, you must pay X amount of money, and the court said that X amount of money was not legally charged. So in that sense, there was no question about voluntariness. What I'm assuming the reason why you choose the unjust enrichment thing is to possibly make the voluntariness or not irrelevant. Just the pure fact that it was a statutory violation, even if you paid it voluntarily, makes it unjust to keep the money.
Yes, right. I see that I'm out of time. May I just...
You may answer his question.
Answer that question. So that's correct, Your Honor. And I still dispute the characterization of it being voluntary. But in any event, getting back to the point you were making, that the voluntariness of it somehow vitiates the unjust enrichment claim, I think is wrong. Because, and going to the point you were making...
It has to be premised on it. How could that possibly be wrong?
Well, okay, so unjust enrichment is, as has been stated, is not about fault. It's not about the violation. It's simply about money being in one person's hands that should be in another person's hands. And I think that we satisfied that in case. There's $7.90 that's in ATS's hands that should be in Mr. Pincus's hands because it was unlawful for them to impose any additional fee, fine, surcharge, or cost, and illegal to collect a commission for all the other reasons. So With that, I'll close, Your Honors. Thank you.
All right, thank you. We thank you all for your arguments in this case today. The court will now proceed with the next case, Sievers versus the State of Florida.
May it please the court. My name is Karen Kinney. I represent Mark Sievers in this capital
Ms.
direct
Kane, could you
appeal.
pull the microphone down a little bit? I think
Okay.
that'll give you better coverage
Is that
there.
better? I'd like to reserve 5 minutes for rebuttal. The state had a problem in this case, and the problem was that the entire conviction of Mark Sievers depended on the jury crediting the testimony of one witness, Curtis Wright. And the problem that the state had is that Wright was essentially a bad witness because he had previously made statements to the detectives that Sievers had not hired him, that he knew nothing about any marital difficulties with the Sievers. And he went into his plea proffer with the detectives and the prosecutors, and he told an inconsistent story from what ends up being his story at the trial. He told them that he was actually not present at the time of the murder, and that Jimmy Rogers did the murder alone. And it's only halfway through that proffer that he changes the story when they tell him he's not being believed. And at that point, he says he prayed, which we objected to. That was overruled. He said he talked to his attorneys, and he came back and decided to tell the truth. So the state approaches this case by putting up front on direct in their case these prior inconsistent statements with the attempt to convince the jury that now that he's made this deal with the state, he is going to be telling the truth. So there's an inherent vouching for his credibility just in the fact that they gave him the deal.
How is that not true then of every cooperating witness?
Well, I don't know that every cooperating witness has made inconsistent statements and has made a plea agreement that, obviously the state uses cooperating witnesses, but this case is rather unique because there's no corroboration.
What about Rogers' cell phone? That moves through traffic, right? That corroborates the movement of Mr. Wright and Mr. Rogers, doesn't it?
There is plenty of evidence that Mr. Wright and Curtis Wright and Jimmy Rogers did this crime. So the state did not need to make a deal with Curtis Wright to convict Wright or Rogers. The only reason it needed to make a deal was to get to Sievers because it had no evidence that tied Sievers to the crime without Curtis Wright.
I understand that argument. I guess where I'm losing you is I don't understand why this is all that different from any other case where the state has conferred a benefit on a cooperating witness who has changed his or her testimony, which I think you'd struggle to find a cooperating witness who didn't change his or her testimony over time, didn't engage in some progressive truth-telling. So help me understand the limiting principle of the rule you're asking us to adopt with respect to Mr. Wright.
The rule I'm asking you to adopt, where I'm going with this are the evidentiary errors that occurred when okay, so Wright tells them that Sievers is not involved. So in order to take his deal, he has to renounce his prior official statements in police interrogation. In order to take, and this deal gives the state the right to find that he has breached the agreement, even after he testifies, and he has no judicial remedy for that. So it's very one-sided, this contract that he's entered into. They can find that he breached, and he has no way of arguing about that. And the other thing was that...
And didn't Mr. Sievers' trial counsel try to exploit that weakness in the state's case by thoroughly cross-examining the witness about those prior inconsistent statements and his motive to lie and all of those things? I mean, the credibility issues were played out in front of the jury like you would expect in a case where the state has those problems, correct?
Well, no, because the defense was hampered, and that's where my first three issues go to that. Because what happened here was the defense was trying to show that the state had a contractual benefit in that plea agreement, which was being able to test Wright with a polygraph exam. And it declined to do that. And when you think about it, the reason it declined to do that was because they probably thought there was, if he didn't pass, then that would essentially scuttle the entire prosecution of Sievers. If there was any kind of exam result that showed that he was not being credible. And so that when they didn't, so the defense was trying to exploit the fact, which was a fair argument, that the state had declined to give the polygraph exam. And my first issue goes to that, because what happens is there's a pushback every time the defense is trying to make that point, and that's their key point. And so the defense closes his closing argument by asking the jurors, do you trust Curtis Wright, and would you feel differently if a polygraph had been given? Now, the jury leaves for a short break, and the prosecutors make an objection and convince the judge to address the jury when it comes back. And the judge addresses the jury and says, if Curtis Wright had been given a polygraph exam and he passed it, that result would not be admissible in this trial.
Counsel, can you tell me where is the error in that statement? Is that a misstatement of the law? It's not an opinion on the case. So how is that an error?
Okay, well, we have black letter law in Florida that a judge may not sum up evidence, comment to the jury on the weight of the evidence, the credibility of the witnesses, or the guilt of the accused.
But that's a statement of the law, unless I'm missing something.
No, I was wondering which category you were going to place this statement in among those.
Okay, this is not a statement of the law because, first of all...
Well, isn't it an accurate statement of the law that polygraph results are not admissible in evidence?
Well, that's not what he said. He said if Wright had been given a polygraph and passed it, that result would not have been admissible in this trial. And I'm sorry, I don't think that is a correct statement of the law.
You're saying if he'd been given a polygraph and passed it, that would have been admissible?
Okay, well, the way that it came out that he wasn't given a polygraph was that Sievers asked the detective, was he given a polygraph? Sievers asked Wright, were you given a polygraph? And there was no objection to that.
Maybe I'm missing something here, but I think this whole thing about the polygraphs just seems like an enormous diversion and kind of an improper area of inquiry. Now, if assuming that the agreement did not exist, and Mr. Wright's on the stand, and Mr. Sievers' counsel says, have you taken a polygraph examination that verifies what you're telling the court today? That would obviously be improper, wouldn't it?
Yes,
Well, I don't
because-
understand why, in
okay, 'cause-
principle, this is different.
Well, I think that the trial judge had the same problem, but this is different because we have he is testifying under a contract, and there are contract provisions.
He's testifying under oath. He's testifying under oath, and the contract, I'm just can't understand how that affects
Okay, but-
why it's proper to talk about a polygraph when a witness is being examined.
Because the state put him on and said, the reason why he's now going to tell us the truth is because he has promised to do so in this plea agreement. And the plea agreement was entered into evidence without objection by the state, and it has these provisions about them giving him a polygraph, and they declined to do that. So Severs can't prove that Wright is lying, but he can show that he wasn't properly vetted with the investigative tool that the state had bargained for.
Isn't though, but I'm sorry to interrupt you, but isn't that the bottom line though, what Justice Lawson asked you about, is that the lying, the wanting to get his wife out of the problem, the kind of implication that the state was sort of willfully ignorant of, possible problems with the testimony. All of that was brought out through the questioning. It was argued in the closing. I mean, it was, it was completely there for the jury to accept or reject that view of things, and obviously they rejected it. So what's the problem?
Well, I disagree that everything was brought out, because one of the things that we weren't able to bring out was this entire video that has a lot of information in it, and also information about the wife.
The issue with the video that you talk about is this whole thing about the blip stuff. And that was asked about, both sides asked, I think both Wright and Levitt, about that whole exchange about the wife being a blip, and wouldn't, all the whole back and forth about whether it would somehow be in Wright's benefit to say what the state, to give this testimony in exchange for the wife not having any further scrutiny from the state. I mean, that was, again, putting aside the merits of all that, it was brought out and it was put in front of the jury. I don't understand how that video clip would have, what difference that would have made.
We were trying to put in the entire video. That's a short clip that he wanted to emphasize. That's all you have, but you have the transcript of the entire video. And that video has a ton of information in it where, they go through the plea agreement. The prosecutor goes into this whole situation with him where Wright wanted to
And
get,
if I remember correctly, the objection at the time that it was sought to be introduced was hearsay. Is that correct? I mean, you used, the transcript was used to, okay, and,
yeah, the state said that it was hearsay.
right?
And the defense said, you've opened the door, and this shows his bias.
Is there an open-the-door exception to hearsay?
Yes, because the state asked.
801 what?
The state was saying, oh, he can't admit this because it's hearsay. And it wasn't hearsay, because we were not trying to admit it for the truth of the matters
Was that
asserted.
argued below?
Yes. Yes, that was the argument, that the state brought this up before the jury had come back and said, the defense has just showed us a video, and they knew what it was. Everybody knew what it was. That the whole transcript had been put into evidence at Severs' bond hearing years before, and the judge was very familiar with this case. And
Okay, can you, which issue are you talking about right now?
okay, well, we've kind of gone back and forth, but there was this assertion that we had all of the ability to bring, to test Wright's credibility. And I'm saying,
I would suggest that we're going back and forth, because in response to questions about one issue, you're jumping to another issue and bringing up something completely new. So now what issue you're talking about? Because it's difficult to follow.
Okay, well, I mean, I can go to whatever issue you want to talk about, but if you're talking about why that video should have been admitted, If you go through the transcript of that video, even at the end of it, there's a lot of information in there that would have helped Seaver's case. And there's, even at the end of it, you can see in there that the prosecutors, they're helping Wright come up with his story. And at the end, they do put to him, the one thing they challenge him on is this fact that he called his wife from a burner phone at 11:36 the night after the murder. And that's put to him, and there's some excuses made about that. And they're getting him ready for testifying because they need him. He's the only person who has any information that...
Counsel, just going back, I think, to Justice Lawson's kind of original point, is it your contention that the cross-examination on this issue was insufficient? Because it seemed to be very extensive, and I think our question is just, what would this transcript or video have provided that would have been different? It seems like the same situation. You had this immense cross-examination, and the video would have just been the same evidence in a different way discussed. So I think that's our question, is what exactly was so essential in the video that was not already thoroughly discussed in cross-examination?
So the video comes up after the state has rested, and the defense did not have an opportunity to put evidence in during the state's case. So now it's the defense's turn to put on his case. And the state has already asked Wright, and he says, yes, I told the truth during that hearing, during that proffer session where this is the whole meeting where he's getting his plea agreement. Oh, I told the truth during that. So the jury should be entitled to see what this is, because it is there's a lot of information in there that they didn't ask Wright about. And there's a lot of information, and it's showing the relationship between the state and Wright. They go through the whole plea agreement. They talk about his wife. There's a lot more information in that did not come out in the state's case. The state very selectively brought out facts during their case.
Okay, so I'm now tracking with you on issue 5, which I believe is the only place that you brought up a challenge to the trial court's sustaining the objection to introducing the entire video. Is that correct? That's in context of issue 5?
Yes.
Okay, and in issue 5, that is where you were talking about the blip, and so portions of the transcript were used to cross-examine witnesses. Is that correct? Throughout the trial?
Portions of the transcript.
The transcript from the video that you wanted introduced later were used to cross-examine witnesses, and statements were used from that transcript, correct? It's in the record. It was used at trial.
There was some cross-examination on these statements.
Skip
yes.
that. At some point, counsel offered the video into evidence, wanted to put the whole thing to evidence. There was a hearsay objection. Is that correct?
Yes.
Okay. And what was the hearsay exception that was offered in argument to the trial judge?
This showed bias.
Okay, and that is not a hearsay exception, is it?
Well, it's a different...
Is it a hearsay exception? The objection is hearsay.
Right.
Trial counsel is responding to the trial judge and asking, what's your response to the objection? He says, well, it's offered to show bias. That does not address the hearsay objection, correct?
The proponent of the hearsay objection, so it is a separate grounds for entering a piece of evidence, and the hearsay will not defeat it, because the defense has a right, a constitutional right, to show bias on the part of the witness.
So you're saying that the rules of evidence do not apply if the purpose of submitting the evidence is to show bias? That's your argument to us as to why the trial court was incorrect in sustaining the objection?
It wasn't hearsay, because it
was
wasn't
that argued
being
to the trial
offered.
judge?
Yes.
It was not argued to the trial judge. The only thing that was argued was it's offered to show bias. You argue in your brief that it wasn't offered to prove the truth of the matter accepted.
Well, it was being offered to show bias.
Okay.
So it was being offered to show bias, and the state had opened the door by asking him if he had been truthful in that hearing.
But you recognize bias is not a hearsay exception, correct?
If you're talking about the list of statutory exceptions, I'm assuming that,
The video was an out-of-court statement. There was a hearsay objection, correct?
yes.
Okay. And based on the argument to the trial judge, the response was, well, it offered to show bias. And you're arguing that the trial judge was incorrect in ruling on that objection?
Yes, because we had a right to show that the bias was his relationship with the state. And that was coming out through this whole video where he's making this deal with them to testify and change his story to satisfy what the state wanted from him.
Let me go back to Justice Grossan's question from a while ago. What in the video that you would, if admitted in evidence, would it have shown that you did not somehow present in cross-examination?
Well, I could probably write a whole entire brief on that because it's a 200-page transcript, and there's a lot of information in there, and
That's why I'm asking you the question. What specifically would it have given you that would be that was prejudicial to your client, that would that was an error here?
They're going through, at the beginning of the video, they're going through this plea agreement. The prosecutor is telling him then that, we have this information about your wife, and if you're not going to go along with this, I'm going to tear this up. And the entire scenario shows that Wright is against the wall, and then they go through very carefully over and over again this story, and they're very friendly with him. They help him make excuses and craft this story. And at the end, they even ask him about, they've figured out that his wife had this burner phone and there was this communication, but they help him make an excuse about that. Oh, you were just married and you're probably just calling her to say hi.
So what specifically facts are in that video, not on cross, that would be a winner for your client, that would cause us to reverse this case? Don't tell me what the whole video shows. What specifically is prejudicial error by excluding the evidence?
Specifically, the relationship between the prosecutors and Wright, and his.
So, in legal terms, how is that prejudicial?
Because he was a biased witness who had to satisfy the state. He wasn't an unbiased witness. He was a biased witness.
But it was known that he had a deal, right?
But this is the best evidence of this deal, and more, that the involving of his wife, and it wasn't just that he signed a piece of paper. It was how this whole thing came about, and what they knew, what he was telling them. There was a lot more in that, and so I mean, that alone should have been admitted, and that was a big part of Seaver's case. But I really think that you shouldn't overlook this this argument that he had about the polygraph. And when the judge was making this comment to the jury, it was strange because it's not really a legal instruction. It's rebutting it's rebutting the argument that Seaver's counsel had just ended with on closing. And it's delving into the credibility of Wright, because it's telling the jury that something that was just happened in closing that Seaver's was relying on, the fact that they didn't give him the polygraph exam, should be considered as not having done all of their due diligence before they put him on, and then it's rebutting that by saying there's something wrong with that argument. And it's going into the facts because the facts are the fact that he didn't get the polygraph exam that the state had bargained for. And it's going into that by telling, invading the province of the jury and telling them essentially that they shouldn't consider that fact. So there are a lot of issues.
I mean, I do question your characterization there that the judge told the jury you can't consider that, because the judge allowed the argument and the questions about the agreement, including the fact that the state did have the opportunity to conduct the polygraph exam. Is that correct? I mean,
Yes,
is
without
that correct or
objection,
not?
I mean, allowed without, right, there was no objection to
Okay.
the contract going into, plea agreement going into evidence.
Okay.
So they had that before them, and they had the information that he was never given one. So for the judge to say, if he had passed,
I mean, reading the whole line of question, what was said about the polygraph in front of the jury, they could have been led to believe, seems to me, that polygraph results are admissible. And if the state had just done that, then the jury would know that the polygraph result. And is that correct? I mean, that's...
well, we never said that. I mean, the issue was, did they give it to him? Did the state use their investigative tools to give it to him? So it was and Seaver's defense said, we're not making an issue about admissibility. The question was, did they give it to him? And so when the judge delves into this, okay, polygraph exams, the general rule should be that it's, and I believe it is, that they're not admissible to show the guilt or innocence of the accused. And this was not being used for that. This is different because this is a witness who the state is using and has made a contract with and used that as a provision of the contract. So the question here on admissibility of whether a witness who makes a contract and whether or not their test result would be admissible, I think it is incorrect to say that if he passed, it would not be admissible, because the state can, I mean, the defense can ask him about that, and no one's going to object if he passed.
You really think the law in Florida is that if he passed the polygraph test, that the jury would get to know that? That's exactly what you just said, and you really
wouldn't
think that that's
object to
true?
it.
Well, I mean, if the defense asked about it, if the defense asked the questions that it had asked in this trial, then the result would have come in. I mean, they asked, did you give it to him? So not necessarily the result, but
wouldn't that be ineffective assistance of counsel if you skillfully maneuvered to get admitted a polygraph results that shows that this witness that is adverse to your client was telling the truth?
if the question, okay, they're putting him on as someone who's telling the truth. So if they, and they're saying, he's telling the truth. So if they say, did you give him the polygraph? And the answer is yes, well, we're not necessarily going to go to whether or not he passed. But if he didn't pass, then they probably wouldn't have even been having this trial. So the question...
Ms. Kenney, you have used most of your rebuttal. We've helped you.
Okay. I'm sorry.
We get through that. But what I will do is I'll give you 4 minutes for rebuttal.
Okay. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Christina Pacheco, and I represent the state of Florida in this case. Your Honors, the problem that Ms. Kinney states is the main problem with this case is not a problem at all. As Your Honors acknowledged, Curtis Wright was, the jury knew all of this information about Curtis Wright. The jury knew that Curtis Wright entered into a plea agreement in exchange for his testimony. He was getting 25 years. That was never hidden. That was the defense's theme throughout the trial. The jury knew about the inconsistencies in his statement. The jury knew that he initially lied to law enforcement and said he wasn't involved, and then once he was arrested, he gained counsel. He talked to the state and for a plea statement, and then during the plea statement, there were some inconsistencies. The jury knew about all of these times that Wright was inconsistent. The jury knew about the terms of the plea agreement, and when the agreement was entered, the conversations about the prosecutor and his wife being a blip on the radar. The questions asked of Wright during trial included the fact that he was concerned about his wife before he entered into this plea agreement. Of course, he would want to do what he could to protect his wife. All of that was brought out during cross and recross, and also the detective's testimony. So the jury knew all of this information, and they chose to believe Wright. On appeal, there's really nothing that we can do about that, as Your Honors know, in terms of the fact that the jury chose to believe Wright. In terms of the judge's instructions, Justice Grosshans and Kennedy both acknowledged that the judge's instruction to the jury was just a correct statement of the law. I'd like to point out that it wasn't actually preserved, the argument that this is an incorrect statement of the law. That was never preserved, but more importantly, it's the judge's role to instruct the jury, and the judge merely said that if Mr. Wright had actually taken a polygraph, those results, if he had passed, would not have been admissible during the trial. And there's nothing wrong with that statement. It is correct. If Wright had passed a polygraph and the state used that during trial, I submit we'd be up here arguing that fact. I don't agree with Ms. Kinney's statement and this being an incorrect instruction. And I think that it was proper and warranted given the implication of defense counsel's argument, and it left the jury with this implication that Wright needed to have a polygraph conducted in order to show that his trial testimony was truthful. So under those circumstances, it was warranted to correct that implication. But in terms of Ms. Kinney's argument that the defense was hampered regarding the polygraph, that there was no way that the judge hampered the argument in any way. During the trial, that was the defense's main theme, and it played out throughout the entire trial that the Wright entered into this plea agreement. The state, with a plea agreement, had the opportunity to give Wright a polygraph exam, and the state chose not to do so. The defense was never precluded from asking any questions or making any argument regarding that fact of the plea agreement. So that came out throughout the entire trial. In terms of, I believe that addresses all of the issues. Is there anything that the court wanted to discuss?
Can we go to issue 12, please?
Sure.
State's contention that it showed good cause for the updated notice under 7.8. You concede that there was no showing.
Yes, Your Honor. It's our contention that the state did show good cause. The judge found that the state had good cause to amend the notice.
What was the good cause?
The good cause was that the judge found that what was pleaded in the state's notice or motion to amend, and the state said that the delay was inadvertent It was just a matter of 5 days between the original filing of the notice and then the motion to amend, which included the inclusion of the aggravating factors, and that nothing had occurred during that time frame in terms of discovery or case preparation, and there would have been no prejudice to the defendant.
That suffices as a show. Doesn't good cause that there is a justification as opposed to an explanation of, it sounds like you're saying it was just tardily filed, oops, and the court then found good cause shown. I'm a little concerned about that as a basis for finding good cause shown. And I'm curious if there's a case you can direct me to that would say that this finding is in fact sufficient as a showing of good cause.
Well, Justice Coriel, I understand your concern, and the judge found good cause based on those reasons. I believe there was a case cited in my brief that dealt with a clerical error, and that was the reason why there was a mistake in a notice. It wasn't under the statute, but it was a clerical error. But I think the more important matter is that while the judge did find good cause, the spirit of the statute was the state complied with that. There was substantial compliance with the notice.
I'm not sure I would argue about the ghosts inhabiting this statute. I would deal instead with its words. And I guess my question for you is, isn't your better argument to tell us what kind of discretion we should be giving the trial court here? What do you argue that our standard is on this?
The standard is abuse of discretion, and that it was within the judge's discretion to find good cause. He looked at all of the circumstances. He held a hearing. He listened to the argument from parties, and while the judge the state didn't really elaborate on the fact that it was inadvertent, it was, the statute did just change, and it was just a matter of days that the state realized and added the addition of the aggravating factors. So
it is, though. I mean, I think this is kind of a messy issue for you, though, in the sense that the discretion, it's bounded. I mean, so first of all, the statute doesn't say anything. We have our rule that's kind of the counterpart that talks about good cause. I guess if we read the rule and the sort of the baseline 3.050 about extensions of time, and it talks about good cause on the front end and then excusable neglect if you've missed the deadline. And I think what Justice Coriel's questions are getting to from our perspective in terms of precedent, it seems like it would be a stretch for us to call this either good cause or excusable neglect when it just looking at the record fairly, it seems like the prosecutors just weren't aware of the new law or forgot about it or whatever. The initial notice only referred to the discovery thing. And so it seems like if we get to the end, so there was even though cert was sought, that didn't happen. So we get to the end, arguably we default to the harmless error statute. Obviously, if the question is just was there prejudice, it seems 100% obvious there was no prejudice. But whatever we say about this seems like also has to inform what courts would do if it were taken up in a cert proceeding. And it seems like, in this case, you basically just had a sort of dropped ball situation, and you have a notice that was really kind of, I think, I'm not even sure if you can get to the amendment issue when the notice itself is so defective in the sense that, you're supposed to say that you intend to seek the death penalty and what the aggravators are. If you don't even have the aggravators in there to begin with, then I think you could argue that it's the same as essentially not having given notice at all. And so you're not even, if you're working under the world of the statute, you're not even in the amendment category because, you can't seek the death penalty if you don't know that you're going to be able to prove an aggravator. And if you don't say what the aggravator is, then have you even really sort of given notice on period? So help us kind of think through, what we say about this that could inform not just in a situation like this where it does go to the end and you arguably can do harmless error, but if it is taken up in a cert petition, would the right answer at that stage have been that the state's out of luck and there's no possibility of the death penalty in this case?
Well, no, Your Honor, because the statute does permit the amendment to occur. So I think if there was no, if the state would be out of luck and there's no death penalty, I think that should be expressly provided in the
So
statute.
upon a showing of good cause. So we would have to say that that essentially ignorance of the new law is good cause for allowing an amendment.
Or your honors could find that if your honors did not believe that the state or the judge's finding was correct in finding good cause, that the error was harmless and there was no prejudice, and that the state substantially complied.
And that's the problem. So that solves this case. But it seems like when you're at the cert stage, you don't get the benefit of the harmless error safety valve. They have to decide it on the merits then. And if this case had been decided by whatever DCA it was at the cert stage, if they hadn't dismissed it, would the right answer have been, sorry, state, you either can't meet good cause if we only look at the statute, or if we look at the rule, you can't show either good cause or excusable neglect?
Well, I think that we're assuming that I think we have to jump and make an assumption that the state, the issue is that if you're not agreeing with the judge's decision, but the record is really, other than the state saying it's inadvertent, I think we're making conclusions as to why the notice of the aggravators was not included. So
Right.
I think,
And the state I think it's in its response to the motion to strike, it said, basically it focused on the absence of prejudice, which seems like that's a separate question from good cause.
Yes.
Good cause is looking at kind of what was affecting the failure to file or the need to amend. The absence of prejudice is kind of a separate question. So it seemed like by focusing on that, the state was kind of, they said it was inadvertent, and then they moved straight to the absence of prejudice. We obviously don't want a precedent that says just inadvertence is good cause, right?
yes. I think then the record needs to be expanded in terms of what went wrong. I think that we can't really read into it in terms of why it wasn't included other than it was inadvertent. But I understand the concern. However, I think that if this court wants to give instructions as to what should be involved with a finding of good cause, that would be completely understandable. It needs to be a more elaborate finding. But I think in this case, the ultimate conclusion should be that it was harmless under these circumstances of just the 5 days between the initial notice and the amended notice, and it was over 3 years between when the aggravators were provided and the trial occurred. So the purpose of providing the aggravators to prepare for trial, it was not hampered in any way, and the purpose of notice was to substantially complied with the spirit of the statute, and it did not prevent.
Has there ever been a case from this court that addressed this situation?
I don't believe so, Your Honor. I would be happy to conduct some more research and provide any cases that maybe may help this court in reaching a decision. The only case that I know of from this court dealt with the retroactivity of when a case goes back for resentencing after Hearst, and that obviously is not the situation here, but I'd be happy to conduct further research on the issue of good cause and supplement it for this court's review. Are there any other further questions? The state therefore respectfully requests that this court affirm the defendant's convictions and sentences.
Thank you. Rebuttal argument.
On the issue of the state's notice, the state filed their notice after Seavers moved to strike their 3.202 discovery notice, and it filed it the same day. So that was 49 days from the May 9th date and 53 days from the May 5th date.
So
And-
should we just kind of go with the spirit of the statute and say that even though under your theory, their arraignment was waived, that we should act as if there were an arraignment and that it happened 4 days before the scheduled date?
Well, under the case law at the time, the waiver acted as the arraignment.
Where
So, but-
where that 1 second DCA case where the court said we don't see any reason why. I think the extent
Yes.
of its quote unquote analysis was one sentence where it says
Right.
we don't see any reason why we wouldn't start the clock now.
Yes,
But
that
so it
would
seems
be
like
the-
you're asking us to be, and I like formalism. I like sticking to the letter of the law, but you're asking us to be, hyper formalistic with the 45-day thing and saying that, the amendment, it's not even an amendment because the notice was defective, but then we're supposed to ignore the fact that on your theory, there essentially wasn't an arraignment. In which case, if there wasn't, then arguably the statute doesn't even apply.
There was a date where he was brought in after the prosecutor told the judge that his written plea of not guilty actually wasn't a written plea of not guilty.
Right.
So he's brought in on May 9th, and the state
Okay,
doesn't
so,
file
but
at
hold on.
782.
I'm sorry to interrupt you, but if you're going to go down that path, then there was an arraignment. The initial notice was timely, whether it was kind of fatally defective for not having had the aggravators. I think, isn't it conceded that if you start with May 9th or whatever the date was, and you start the 45-day clock from there, this notice was issued on day 44.
His Rule 3.202 notice.
Right.
Which had no aggravating factors in it, which
Okay.
wasn't under the statute. And I'm saying you can't relate back to that because that wasn't the notice that the statute requires. They need to relate back to that, and then they need to say that he had good cause to amend. So they
Right.
need to take two leaps.
So can you tell
get
us?
there.
Can you tell us why? And I completely understand if we focus on the front end. I understand the arguments you're making, but why? What reason would our court have for not defaulting to the harmless error statute, where the legislature in 782 whatever is silent on a remedy, but it does tell us this? It does have this kind of catch-all remedial harmless error statute. What basis would we have for not applying that here? Because you agree that if we do look at prejudice, there's zero prejudice, right?
Well, I don't think that that's even a consideration.
Okay,
because-
right. So
yeah.
you think the harmless error statute shouldn't even apply. So tell me why.
No, because this is a legislative a time bar that I don't think that how can you make a harmless error analysis?
Well, are you saying it constitutes fundamental error?
I'm saying that it's a time bar that the legislature put in place as a benefit to the defendant. And I don't think that there's any room for, it almost like a jurisdictional bar to the death penalty. They have to meet this time bar. And there's no wiggle room there unless
So,
you're going to
Counselor,
make
you
some.
view this like a statute of limitations type issue, where if they
Yes.
file after, there's no harmless error because there was no jurisdiction.
Yes, for the death penalty. That's how this court should apply it, because it's not gray.
You've used your time up, but you
Okay.
can take another 30 seconds to sum up.
Okay, I just want to say that without Curtis Wright's testimony, the state has no evidence that Severs was involved in this murder. And a number of errors that were discussed in the first part of the brief, they combine to bolster the credibility of Wright. So I'm asking this case to reverse for a new trial, because these errors enhance the jury's view of Wright's credibility and give undeserved credence to his story. And it should go back for a new trial with the understanding that this should not be a death penalty case. Thank you.
We thank you both for your argument in this case today. The court will now stand in recess.
All rise.